Hey, good morning, everybody. This is the City of Camilla called council meeting. This meeting was called, today is Thursday, July 27th, 2023. This meeting was called by the District 2 delegation. The District 2 delegation is Councilmember Tucker, Councilman Palmer, and Councilman Collins. And at this time, we're here at the first floor at City Hall. And at this time, I'd like to ask Melinda, if she wouldn't mind, sitting in for our awesome city clerk, to call the roll, please.
Councilmember Tucker. Present. Councilman Burley.
Present.
Councilman Collins.
Here.
Councilman Palmer.
Here.
All right, and let the record reflect that council members Pollard and Morgan are on the dais, and we will have more clarification on that here very shortly. Madam Clerk, just make that note, and we'll get into the details of that here fairly shortly.
Okay.
All right, at this time, I'd like to turn to our city manager and lead us in prayer, please.
Be my pleasure, Mr. Mayor. If you would, everyone, just bow your heads for a moment of prayer. Oh, precious God, our Lord and our Savior, once again, Father, you ordained this moment for these men and women to come together to discuss the business of this city. God, I pray right now that your patience, your love, your kindness will prevail, and clear heads will be all around. God, I pray for each and every citizen that are represented here today. And God, I pray that as their voices are heard, God, that these elected officials, this leadership will guide and listen, and God will just do the best that we can to conduct the business of this city. It is in Jesus' mighty name we pray. Amen.
Amen. All right. So at this time, let me verify. Attorney Wiley, can you hear us?
We can hear you, Mr. Mayor.
Okay, perfect. Thank you. All right. So at this time, is there a motion? Sorry, everybody. Let's go for the pledge. Pledge allegiance
to the flag of the United States of America and to the republic for which stands one nation, under God, indivisible, with liberty and justice for all.
All right. Thank you, everybody. All right. At this time, is there a motion to approve the agenda for today?
I'd like to ask a question, please.
Yes, sir.
I'd like an opinion from the city attorney as to two individuals sitting at this table that are not council members. What is the legal opinion of that, please?
Well, yes, sir. So what we're going to do, Councilman, is you guys call this meeting. We're going to get to that part, as I said earlier, at the onset. So what I need right now is you guys' agenda. If you don't want to do it anymore, that's your business. But what I'm asking is there a motion to approve the agenda for today?
I'd just like to note that I object the participation of the two former council members participating in this meeting and sitting here with us. They have been removed from office by an order of the Superior Court of Mitchell County, and that is in conformity with the city's charter.
Okay.
So, and also, if I may, I would like to, in raising that objection to their participation, present this order so that it is in the record.
Absolutely. Again, once again, everybody, is there a motion to approve the agenda for today?
So moved.
Second.
All right, we have a motion that's been properly second. Any discussion? All right, everybody, as Councilmember Palmer and Councilmember Tucker has pointed out, as it relates to the presence of Councilman Pollard and Councilman Morgan, let me go first. Other than two council members, anybody, is there any discussion here? All right. So, it is my understanding that there was a civil case outside of the city of Camilla that involved two of our council members in their individual capacity, if you will. As part of that process, and I know that there have been reports or something similar to that in local media relating to that particular civil procedure, and I think what has been conveyed to the public that process was over. That process is not over. That's why these two men are up here. I will now turn to our city attorney to give you a little bit more detail, and this is for the public, so that you guys understand exactly what is happening. So at this time, Attorney Wiley, I'll turn it over to you to go ahead and explain to the council and to the public why Councilman Pollard and Councilman Morgan are sitting here today.
Thank you, Mr. Mayor. We're having slight technical difficulties, so there's some feedback. We will pause briefly and get back with you. But we did send a memo out this morning, and my apologies, members of council, is that if you have not received it just yet, because we were made aware of certain information this morning that occurred this morning that changed the nature of today's proceedings. And as Councilwoman Tucker has indicated, there was a petition for forewarned law. Just 1 second, where did I take her?
And we do not have her email.
Oh, okay, that's lawyers. Side moving side IT stuff. So I have my esteemed colleague Alicia Thompson here with me, Mr. Mayor and Council. So good morning to you all again. Yes, there was a petition for forewarned codes. I understand that was filed sometime last November against the two city council members, Mr. Pollard and Morgan, and that petition sought to declare those two individuals ineligible to hold office due to allegations that they did not reside within the city limits of Camilla. It's our understanding that recently on July 17th of this year, there was a scheduled trial or a determination by a jury as to whether the allegation of residency for each individual had merit. However, prior to the paneling of the jury, the trial judge accepted a motion, entertained a motion by the petitioner counsel to strike the answer in defense of Messrs. Pollard and Morgan. The court granted that motion, struck the answer, and entered default judgment against those two individuals. As a result, the court followed up with a written order on July 20th, it's our understanding, 2023, and the court issued an order on July 20th, 2023, and establishing as a matter of law that those two individuals were not allowed to remain in their elected offices of city council members for the city of Camilla. The following day, based upon the court docket, each individual filed a notice of appeal of that decision to the Georgia Supreme Court. That did not end the matter, and the court's order was still in effect, meaning result of the July 2023 order, the individuals were removed from office, ousted from office as a result of the court's entry of default judgment against them. However, it's my understanding that this morning, prior to today's meeting, that in addition to the notice of appeal having been filed on Friday, July 21st, this morning, on July 27th, these individuals filed into the Superior Court clerk a summons representing the payment of all costs incurred during at the trial court level. And that's relevant for several reasons. Under Georgia law, once an individual filed a notice of appeal, which was done on July 21st, and filed the payment of costs incurred in the trial court, which was done this morning, the effect of the trial court's order entered on July 20th, 2023, is therefore stayed. What does that mean? The effect of that particular order has been suspended until final ruling by the Georgia Supreme Court. What does that mean for purposes of today's meeting? It means that the two gentlemen, council members Morgan and Pollard, have now been resumed to their duly elected offices. District 1, District 1, Post 3, and District 3. District 3, Post 1, I believe. They are now allowed to resume their elected position until final ruling by the Georgia Supreme Court or some other intermediary ruling of some other nature removing the state. That a court warrant tub is nothing more than a civil proceeding, just like any other civil proceeding in the state of Georgia. Every civil litigant has a right to appeal to a higher court to have a review of the trial court's order. The effect of filing that appeal and the payment of the cost renders the trial court's order stayed or suspended or held in abeyance, whichever term you would like to use, and the obligations, rights, duties of the individuals affected by that order are held in abeyance, and the status quo is remaining in effect. So the fact that that decision allows these two gentlemen to sit here and continue to serve as a lawful, duly elected member of the City Council for the City of Manila.
All right, any other questions?
Yes, Ms. Wiley. There is an effective order that is in place that removed them from office on 7/20. There was a mandate in that order for them to turn over the devices that were owned by the city, phones, iPads, etc., within 48 hours. And the only thing that would halt this order would be Judge McCorvey issuing a stay, and that has not occurred. A stay has not been granted by Judge McCorvey. So I'm in disagreement with just filing a notice of appeal, which is your intent that you plan to appeal. Now, they still, of course, have the right to appeal it. The transcripts are not even back in, from my understanding, for them to even be able to file an appeal. But what is on the table right now is an order by a senior superior court judge, and we are prepared to proceed with what the charter allows us to do with a vacancy.
Yes, sir.
This is Danny Paul. I disagree with your opinion. I want to hear the Superior Court judge say that they are allowed to continue as council members, and until that happens, I consider this to be illegal.
Well, I can assure each of the council members who have spoken that Georgia law, the OCGA 5-6-34, 35, and 36, govern the impact of appeals.
And Attorney Wiley, my apologies. If you can give that code again so that my council members, my colleagues here can take this down and talk to or confer with whoever they need to validate what you guys are saying. So if you can just repeat that one more time for them.
Okay, so it's OCGA section 5-6-46A, and it states, in civil cases, the notice of appeal filed shall nothing but a stay. The law does not require a separate or distinct order from the trial court. The trial court judge has been rested of any jurisdiction in this matter concerning the implementation of the order entered on July 20th, 2023. That issue is now in the arms and the breast of the Georgia Supreme Court. Once the Clerk of Superior Court submits that particular case file up to the Supreme Court, it is my understanding from court information that costs have been paid this morning, which makes all the difference. If costs were not paid, then the notice of appeal, Councilman Tucker, would not have been sufficient. However, Georgia law, the General Assembly, has said if an appealing party files a written notice of appeal and pays the payment of costs assessed by the Clerk of Superior Court, then the trial judge no longer has jurisdiction. That order is now held in abeyance. The filing of those two items, the notice of appeal and the submission of the payment of the costs, operates as a matter of law, as a stay of the implementation, the effectiveness of the order, and that order is suspended until further order by the Georgia Supreme Court or some other intervening order of a different nature.
I do have a follow-up question to that, is how can an appeal be filed when the transcript has not even been prepared? I understand that you're capable of paying the $421.71, but in order to file an appeal, you also have to have the court documents, and those have not been prepared yet. That's why was my understanding from the clerk of the court that the only thing that had been filed, of course I did not check this morning, but the only thing that had been filed was a notice of appeal, and therefore the judge's order stood.
Oh, if you don't mind, Attorney Wiley, I'll speak to that. As Councilmember Tucker has pointed out, she has not checked with the Superior Court clerk this morning. The transcript was prepared last night, delivered to the councilman this morning. That transcript was delivered to the Superior Court clerk along with the court calls. So obviously, if you had not checked, you would not have known that.
Nor did I get the email that she provided to the council.
Well, I want everybody to understand this was happening within the 9 o'clock hour. So this is literally up against this particular deal this morning. And to be honest with you, if and this is back on the record here as it relates to today's agenda, and I think goes to a larger point that I want to make as it relates to whether or not the approval of this agenda is warranted. What we're going to need to do here in this city, this apparent anxiousness to do certain acts, if you will, without conferring with myself or just to ask you questions before this kind of stuff even happens could have been avoided. Because there could have been a conversation about the transcript is in the process of getting done. It will be is expected to be done yesterday. The expectation is that it will be delivered to the court this morning. It's an expectation that the cost will be paid this morning. But those conversations, those phone calls, those simple questions could have avoided all of this. Right now, here in this city, we got children that are going to bed hungry and ordering. You have seniors in this community that need assistance. You have infrastructure in this city that needs fixing. This should be the priority of this council. That should be a priority. Let's make sure that our children are taken care of. Let's make sure that our seniors are taken care of. And let's make sure that we're moving this economy forward. When you're spending a tremendous amount of time on stuff that does absolutely nothing to move this city forward, you end up with the kind of stuff you got this morning. And what I would ask the people of Camilla once again, and I've asked this before, and I ask again. Ladies and gentlemen, if you are relying on your information, on what's happening in this room, and what's happening within the function of your city, if you're relying on media outlets, newspapers, to get your information, I can't do anything about that. What I can express to you, though, if you want to know what's happening in the city, if you want to know what's actually happening in terms of moving this city forward, come to the meetings, or at the very least, watch the live videos for the Facebook. It's unfortunate that information that resembles that civil action was over and this is going to happen and they should have did this and cartoons of sharks and all this other stuff does absolutely nothing for our children and for the people of this community. So I would ask the members of this council to put your energy into moving this city forward. I yield.
Thank you for that spiel.
You're welcome.
More of the same.
Yes, ma'am.
I just have a few comments I'd like to make. One of the priorities I think that we need to stay focused on is that each of us are operating honorably and that we are operating within the charter. And all of this ties back to the charter. The fact that there are requirements within the charter for who can serve. And then there are means made in the charter for when someone is removed by a superior court judge, that there are procedures to follow. So we need to make sure we're upholding what our charter. We all took an oath. Each one of us, elected officials, took an oath that we would follow the charter and the Constitution. And we're adhering to what the charter says, that there is a removal by a superior court judge. What ensues is a special election or an appointment if you have less than 12 months on your term. I will also contend that I cannot name one time in the 2 years that I've served on council that the mayor has ever asked me for input. Even when that input might have been that I had 30 years of experience in that topic. So just understand there's not a lot of communication in seeking out information. What we had before us, and we allowed a week to go by, was a court order that was signed by a judge and with direct order. And when we requested, had the order been followed, the city manager had no response to acknowledging that order had been followed. So we had to go on what we had, an order. And then to Attorney Wiley, I think we have to be very conscious in here in the fact when I spoke with Mr. Denmark about this subject last November, and I needed confirmation from Mr. Denmark that in no way would Denmark and Fisher be incurring any cost on behalf of the city with relationship to the civil lawsuit that was against two individual council members on their own. And he assured me that the city would have no cost whatsoever because it would be not ethical for the Denmark Fincher firm to be involved in this. So I am hoping that we can continue to adhere to that because I do not think that the citizens in Camilla should be paying legal fees on behalf of two council members on this position.
Councilmember, I just want to make sure that the record is clear. Are you suggesting, or are you just?
Mr. Denmark assured me,
Yeah,
and I told him I trusted his word.
I understand that, but ma'am, the language that you're using is becoming dangerously reckless. So my question to you, are you accusing our city attorney of assisting in the trial?
No, Mr. Denmark made it clear to me that
So that's not what you're saying.
it would be unethical.
Okay, good deal. So that's not what you're saying.
I did not, because
Okay, good
I
deal.
told Mr. Denmark that I am faced with a number of constituents who feel like their fees are being paid. I said, no, I trust our
Indeed.
city attorney at his word. What I'm saying is, let's don't let that become something that we're being billed for at this point.
Ma'am, the bills from our city attorney comes in every month. Every month. To my knowledge, Mr. City Manager, I don't recall seeing anything billing for the civil case that's the subject of this meeting today. That doesn't exist. So it's from my perspective, the implication or even the conversation is moot. All right, yes, sir.
Who's paying for these people this morning?
Sir, you guys called this meeting.
Yeah, but they are discussing these two gentlemen.
Sir, that is literally the subject of your agenda
Well,
today.
who's paying for it?
So the city.
All right, that's all I want you to see.
We may ask you questions with Ron.
Yeah, absolutely.
Denmark, the managing partner, Mr. Denmark, the comments he made to you, Councilwoman Tucker, he has honored. Every member of this firm has honored that comment. This firm has not represented an individual interest of either of the council members who are the subject of a petition or court warrant held at the file. We have not engaged in any discovery, litigation, conversation. We've never spoken to these gentlemen. We've never made any contact whatsoever. The memo that was drafted this morning regarding the events that led up to this particular meeting dealt with the composition of the governing authority of the city of Camilla. The client that Fincher Denmark represents is the governing authority of the city of Camilla. When there are potentially two vacancies or allegations of two vacancies within the governing authority, it is our duty, our legal duty, our obligation as city attorney to advise the governing authority who is lawfully part of city council. The city citizens of Camilla need to understand that, and the councilmen and women and the mayor need to understand that. So to that extent, we acted appropriately, ethically, and lawfully in providing a legal assessment as to who can lawfully serve on the governing authority of the city of Camilla. That's what we have done, and that is all we have done. We have given you, and what you are entitled to know is the implications of the order, the implications of the notice of appeal, and the implications of the following of the payment of the cost as it relates to who can lawfully sit as lawfully elected members of the city council of Camilla.
All right.
Question. Did your firm draw up the appeal? Did your law firm draw up the appeal that was filed this morning?
Our office has drafted a single piece of paper that has been filed in that co petition. Not one single piece of paper. We saw the order, we received the order from the petitioner's counsel last week, which alerted us to the filing of the order, and we are allowed to get onto the public site to see whether or not a notice of appeal had been filed, because the lawyers, with over 50 years of experience in this area, we understand the implications of the notice of appeal and paper costs as it pertains to the implementation of the order. So we did that by looking at publicly recorded documents that allowed us to make those legal assessments that were provided to you this morning, sir.
All right. Any other comments? Councilman Morgan, any comments?
I just, looking forward to continuing the business of the city, and kind of just want to make a point out to the community that's watching. Please be alert, please be aware. We still have people in this area, on this council, that are trying to make decisions for your area that you did not make yourself. I think it's outrageous that this call meeting was called by members of District 2 for matters that are happening in District 1. But again, I just look forward to continuing to do the work of the city.
All right. Any other comments? All right. Council, we have a motion that's been properly seconded. Any other discussion? All right, again, what you're voting on, council, is whether or not to approve the agenda for today. Let me just point out lastly, per the law, per the opinion of our city attorney, there are no vacant elected posts in the city of Camilla. So, with that being said, any other comments? All right, Madam Clerk, this will be a roll call vote.
All right, Councilman Tucker,
Yes.
Councilman Byrd,
No.
Councilman Palmer,
Yes.
Councilman Collins,
Yes.
Councilman Ballard,
Absolutely no.
Councilman Wonders.
No. Mayor votes no. Motion fails. Council, it appears that we've reached the end of our agenda today. Is there a motion to adjourn?
What about speaker appearances? Mr. Mayor, we have speaker appearances.
Ma'am, the agenda has been voted down. Is there a motion to adjourn?
Motion.
We are adjourned. Thank you, everybody. Thank you for watching at home. Attorney Wiley, Thompson, thank you very much.